Good afternoon, everybody, and welcome to this PROPcast from Eversheds, Sutherland. Our topic today is leases options to renew. I am Caroline Andresia. I am the professional support lawyer to the real estate practice group here at Eversheds, Sutherland. Today's topic is leases options to renew, and I chose this topic because, like buses, I seem to have seen options to renew in leases come along in threes lately, and they seem to be becoming more market prevalent. And so for something that actually seems quite technical, quite mechanical as an option to renew, in fact, they are have quite a lot of negotiation around the wording of the options to renew, and there are quite a lot of sort of trips and traps that you can fall into from both a landlord and a tenant point of view when using a lease option to renew. So I think there's quite a lot to talk about both from a market perspective and from a legal techie perspective. If I go too fast or don't explain something in a way you would like it explained, please just drop me a message. I will aim to finish promptly at 12 o'clock, so I will move on at quite a pace, but I will always stop and explain if somebody wants something explained. Right, so moving on, let's have a quick look at the first wording. Here it is, the option. The tenant may renew this lease by giving the landlord an option notice during the option notice period, if only the drafting stayed that simple and finished there. Throughout the session, for the drafting to discuss as the topic, I have used the lease option to renew wording that goes alongside the model commercial leases, which are an industry set of precedents available to all through the model commercial lease website, and they are precedents that are drawn up by committee, a committee comprised of both landlord lawyers and tenants and landlords themselves. So that's the standard wording I'm using, as it is the most standardized wording we have. So if you'll see in this option, it is a call option, by which we mean that the tenant can ask for a lease to be granted to it. We're not talking here about put options, where the landlord can require the tenant to take a new lease, which are much rarer. So I'm talking about a call option scenario. The tenant may exercise the option and take a new lease, and exercising the option would give rise to a contract to take a new lease. And the good things about contractual options to renew in leases is that they give the tenant certainty of lease renewal that goes beyond the certainty or lack of certainty that the security of tenure provisions give under the Landlord Tenant Act 1954, or if you're in Northern Ireland, the Business Tenancies Order 96. So if you have a contractual right to renew rather than a statutory right to renew, that contract can't be defeated in ways that 54 Act's right can be, such as redevelopment grounds or the landlord wanting the property for its own occupation. So the option gives contractual certainty for renewal and then possibly certainty too around the terms of that renewal lease and the actual duration of that renewal lease. A court can only order a maximum term of 15 years under the 54 Act, and the court can amend the terms of any renewal lease if it considers appropriate to do so. So a contractual option gives greater certainty to the tenant than just relying on 54 Act rights. Okay, so that's the essence of the option. When and where do we see it? Well, several different sorts of properties where contracts to renew leases and their options are most prevalent. Say in headquarters buildings, here we're talking about signature and perhaps significant office buildings where a tenant expends a lot on the fit-out. There's a high-profile location, for instance, or a type of building that a tenant is particularly known for and wouldn't want to move from. So a building in a particular location, for example, the area of town, say, where all the lawyers are, probably somewhere to be avoided, or where all the insurers are, or where all the art galleries are, for instance. So a contractual option to renew gives you more certainty of being able to stay in situ rather than relying on the 54 Act. So we see it under headquarters leases. Dan, I can see you've raised a question. I'm going to come on to the terms of the new lease on the next slide. So can I just put a pin in that one for now, and I'll come back to you. So headquarters buildings, sale and leasebacks. Another area where we often see a contractual option to renew, effectively where the buyer is buying the income and the property rather than being interested in the asset, and the occupier is selling the property to raise cash, but still really wants to treat the property as their own, even though they are a tenant. So it's a way of treating as their own, they'll include the right to renew to give the certainty of occupation, so we often see options to renew on sales and leasebacks. Then a couple of types of property where they're common, in particular, say, the likes of cinemas and data centres. And there, the reason for wanting an option to renew is a combination really of location and the expense of fit out. These are buildings that cannot easily be relocated or recreated, and so for the investment in the building that the tenant wants to make, the tenant will want to know that it can use the building for the whole of its useful life. So you often see an option to renew there. Typically, for instance, a data centre would be let on a 25-year lease with an option to renew for a further 25 years. And then perhaps for anchor tenants, department stores, supermarkets and the like, here a tenant might want a contractual option to renew to have control over the terms of any renewal lease above and beyond the 54 Act. And in these you might typically see an option to renew which would even allow the tenant to dictate the terms of the renewal lease at the time they exercise the option. So they might be able to pick the term that they want to renew for, or they might want to be able to shrink the size of their store, and they can do all this more securely and predictably through a contractual option to renew under the 54 Act. So those are the kind of situations where we see options to renew arising most often. And then across all properties, there is one extra case where we see options to renew leases being built in, and that is where perhaps the landlord has the right to end the lease before it simply expires. And here I'm thinking of situations where perhaps the landlord can end the lease following damage by an insured risk or an uninsured risk, where either the landlord chooses not to reinstate or reinstatement is impossible, and the landlord will want to end the lease early. And in some situations, you see the tenant say, well, if you decide to end that lease early, I want the right to renew the lease contractually. And this is usually the case, say, perhaps in a supermarket where actually it's very important for the tenant to have a property in that location, some kind of competitive advantage, or because they're not going to be able to find another suitable site, and actually they would want to continue with that property in that site even if the lease has to end early because of damage. So across all the kind of sectors and kind of properties, you might see a contractual right to renew for that reason. And then we come to the why. Why not just not a longer lease? You know, if you think you might want to stay there 40 years instead of 20, or 20 years instead of 10, why take 2 leases of 10 years rather than just a 20-year lease at the outset? Well, in a word, tax. If you take a 20-year lease at the outset, perhaps with a tenant's break at year 10, you'll be paying SDLT on the whole 20 years' worth of rent. For SDLT calculations, break rights and options to renew are both ignored, and so you wouldn't get any credit if you took a longer lease and then broke it. You wouldn't get any tax back. So an option to renew is a way of securing your location and your property, but still deferring some of your tax liability. Why pay SDLT now when you could pay it in the future if you decide to exercise your option? So that is really the other half of the why. Okay, so looking on from the bare bones of the option, the nature of it, and the when and why we see it, let's have a look at some of the extra wording around it, the conditionality of it. So this is MCL wording, as I mentioned, model commercial lease wording. If the tenant exercises the option, if at the date of completion of the new lease, the main rent due under this lease has been paid in full, and there are no material breaches of the tenant's obligations under this lease, the landlord must, and the tenant must accept the grant of the new lease as soon as reasonably practicable. So that's the bare bones of the wording. Let's unpack that a bit. Very often, the option and the right for the tenant to exercise the option, the right to have the new lease, is conditional on several factors. And this is where some of the negotiation comes to light. So, for instance, here, for instance, you only get the new lease if you are up to date with your main rent, your annual rent under your present lease, and only if you're not in material breach of the first lease. Now, if you're a tenant, you would probably want to say that actually those conditions should be fulfilled at the time you serve the option notice, Otherwise, you're never quite sure whether you're going to get your new lease until the new lease is granted. If you're the landlord, you might want to say, well, it's not just the main rent you have to have paid me, you have to also be up to date with your insurance rent, your service charge, so I'm going to make it rents generally. But then if you're a tenant saying rents generally, that could include, sums payable on default or interest sums, and so you wouldn't quite know whether you had paid everything due and you were going to get your new lease right up until the last minute. So there's some negotiation there around main rent, what you have to be up to date with. And then here we've got about that the tenant won't be granted a new lease if he's in material breach under the existing lease. I suppose there's some comfort around using the word material. It can't be trivial, but on the other hand, there are plenty of landlord remedies available for breach of the existing lease. The landlord can just sue you for breach of covenant, and actually, if he has contractually committed to giving you an option to renew, why should he then try and end your option to renew simply because you've got a falling out over a balancing charge on a service charge, for instance? So the landlord does have other remedies for the breach of the lease, and maybe if they've agreed to give an option, they shouldn't try and take it away. You'll see this drafting here refers to at the cost of the tenant. Well, that's usually in square brackets and usually gone, to be honest. More often than not, both parties bear their own costs. After all, the landlord gets the benefit of a longer income stream, a tenanted occupation for longer, and the tenant gets the benefit of the renewed lease that they wanted. So usually both parties bear their own costs. You'll see that if the tenant serves the option notice, the landlord must grant and the tenant must accept the grant of the new lease. So it is the point that the tenant serves the option notice that the tenant is contractually committed to take that new lease. The tenant can't change its mind between serving the option notice and the completion of the new lease. And that's got to be right, because otherwise the tenant could hedge its bets and serve the option notice, but then pull out and not complete the next renewal lease. So that is when the tenant becomes contractually committed, not just the landlord committed to grant, but the tenant also committed to take the lease. Right, so that's the conditionality around having served the option notice within the option period, whether or not you get a renewal lease, often the subject of some debate and negotiation. So let's have a look at the terms of the new lease. Okay, so here we go. This is the definition of the new lease under the model commercial lease wording, a lease of the premises. So that's the default. You just get the same premises again. Or it might be that built into the option will be a tenant's right to specify in the option notice the particular part of the premises for which they want the renewal lease. And it gives them the option to just take a renewal lease of part only. So if you were a tenant of 5 floors of an office block and you had the right to a renewal lease at the end of those, then maybe you would want the right to specify in your option notice, well, actually, I don't want all 5 floors, I just want floors 1, 2, and 3. And likewise, if you were a landlord in that scenario, you would probably want to impose some definition of permitted part, because you might be quite happy for a tenant to renew in respect of 1, 2, and 3, but you might not want them to renew in respect of just, say, 1 and 5, or, part of 1 and part of 4, something like that. So the default is usually that it's the whole premises again, but it doesn't have to be. But if it is going to be just part of those premises, then there needs to be some working around in the option as to what parts are permitted. So that's the lease of the premises, or maybe not, for a term of so many years, starting on the day following the term end date. So the term of the new lease is entirely up for negotiation. Sometimes it's just a repeat of what went before, so 25 years followed by another 25 years. And sometimes the tenant can specify in the option notice the term for which they want to take the new lease. So there'll probably be some minimum and maximum, but in their option notice, the tenant can say, I'll take a new lease of 5 years or 15, and that's part of exercising the option. I should imagine a landlord is likely to push for a minimum, say 5 years. They wouldn't want just a little extra lease. They want something worth having. And as you see, the new lease starts on the day following the term end date. So when one lease ends, the next one immediately picks up. so that the tenant has continuity of the right of possession and occupation. He doesn't have to move out and move back in. That would be a bit of a disaster. Okay? So if the new lease is completed earlier than the term end date of the first lease, it'll just act as a reversionary lease and will kick in when the first lease expires. So there's the term, always up for negotiation, sometimes just the same again, but sometimes not. Two techie traps to look out for on the term. So things to look out for. One is some long lost provision of the Law of Property Act 1922, not even the Law of Property Act 1925, which perhaps we're more used to dealing with, but the 1922 Act, which has a provision that states that any contract for the renewal of a lease for a term exceeding 60 years from the termination date of the original lease will be void. Now, there's no case law on that at all, and in fact, we've recently been to council on the issue, but really it's up in the air. So for safety's sake, the term of any renewal lease should not be more than 60 years from the end of the existing lease, because otherwise you might fall over paragraph 7.2, Schedule 15 of the 22 LPA. Okay, so for safety's sake, make a renewal lease always less than 60 years. And the second potential trap around there is if the lease itself is granted out of a head lease, which could be common, an investor lease over the top of it, for instance. If the lease itself is granted out of a head lease, then you have to be very sure that any renewal lease doesn't take you beyond the term of the head lease. Because if it does, if you underlet for the rest of your term, or even longer than the rest of your term, then that takes effect as an assignment by way of operation of law, which is just a disaster scenario. You don't want to go there. So the two things to look out for on the term, above and beyond the commercial negotiation of what it should be, is don't let it go over 60 years, just in case. And actually, if it is a lease granted out of a lease, make sure you leave yourself at least a day of head lease, otherwise you will have assigned your head lease. So that's premises and term of your new lease, and now we're on to rent. Typically, the new lease will reserve a main rent equal to the amount of the main rent reserved under this lease on the term end date. So whatever you were paying under the first lease on the last day of the term, you will pay under the new lease. It's the rent reserved rather than the rent payable, just in case rent is suspended, say for damage by an insured risk, and it just continues over. It's not a fixed amount usually, because of course usually the terms over the first lease, the rent will have gone up by rent review, so we can't actually put a figure in most likely because we won't know what the rent of the first lease will be when you get to the end of it. So very often it just picks up where the previous lease left. But then very often these renewal leases have rent reviews on the very first day of the term of the new lease, and then the typical, say, 5th and 10th anniversary pattern. And they have that rent review on the first day because it will have been some time since the lease was reviewed under the first lease, perhaps 5 years ago, and the landlord won't want to miss the opportunity to rebase the rent to the open market value now, sort of 5 years later. This is particularly common where the first lease perhaps was a rent review on the basis of RPI increases, so just an index rent, which is really quite common on, say, the sale and leaseback situations, where the rent has just been creeping up by inflation, but has not been tied to open market value. So sometimes you will see that the original lease was RPI, that the next lease has an open market rent review on the first day, and then perhaps goes back to RPI. Probably an open market review on the first day which doesn't let it drop, but at least will give the landlord an uplift if necessary to the present open market value. So very often your lease and your renewal lease might contain two rent review schedules, one to use during the life of the first lease, one to use as the schedule to replace that on the first review under the renewal lease, and then perhaps back to the first again. Okay, paragraph D. This new lease is going to not include, it's going to omit the option to renew in this clause. And that is very, very necessary for fear of falling into another technical trap. Now, sometimes renewal leases do contain options to renew. Maybe the option to renew can be exercised twice or 3 times, but at some point, the option to renew has to drop out of the renewal lease. Otherwise, you run the risk of creating a perpetually renewable lease. And again, this is after statute, but if a lease can just automatically be renewed time and time again, then it is converted by law into a 2,000-year lease. Or if it is a lease granted out of a head lease, it becomes a lease equivalent to the term of the head lease less just 1 day. So in which case, in either scenario, the landlord will have given up really any interest he has in the property, and there'll be a 2,000-year lease, or a lease that's nearly all the goodness less just the 1 day. So at some point, it is really important that the wording and the drafting and the provisions make it very clear that that option to renew falls away. Okay, so that is a big trap to avoid. A guarantor. So this definition of new lease says that the new lease has to be guaranteed by any person who on the term end date is a guarantor of the tenant, not a guarantor under an ARGA, but just a straight guarantor of the tenant. And after all, if the tenant is such covenant strength that it needs a guarantor in the first place, then as landlord you're going to want a guarantor again. Now this is a second lease, a new lease, and so there isn't really any suggestion that this is in the nature of a repeat guarantee that offends the Landlord and Tenant Covenants Act 95. As we know that, under the 95 Act, you can't require a guarantor of an existing tenant to commit to being a guarantor of a next tenant. But that doesn't seem to arise here because we are talking about a new and second lease. Having said that, though, the 95 Act case law is almost surprising, and who's to say that, this guarantee would be found to be invalid? I suppose, strictly speaking, you could say that the tenant had to find a guarantor, an alternative guarantor that the landlord approved, but it might be quite hard to find a decent second guarantor if you don't take the first one. So we will proceed on the basis that because this is a second lease, and because the tenant isn't obliged to take it, it can only take the option, that guarantee will work. And then lastly, otherwise on the same terms as this lease. That's the default position, so that actually the renewal lease will be just the same again, save as to those provisions as to term and rent and the option to renew. But just sometimes, in fact, a whole new form of lease is annexed to the first lease to show what the renewal lease will look like. So maybe on renewal you get a different document entirely. And that's perhaps more common where the first lease has been a sale and leaseback with very tenant-friendly terms. So perhaps the tenant insured, or there was a limiting repairing obligation, or there were limitations on the landlord's right to enter to carry out works, all the kind of typical things you see in a leaseback where actually the tenant still wants to treat the property as if it were their own. And then the renewal lease is on a more industry standard sort of FRI, institutionally acceptable kind of format. So there might be a whole new lease annexed to say that if you renew, though, it'll be a lease like this, and it'll revert to, say, the landlord insuring, and the landlord having the right to go in and do works in default and that kind of thing. One thing to watch out is that sometimes on an option to renew, we don't go for the default at all as the same terms, and the tenant will serve a sort of an advance warning notice that I am thinking of exercising the option, and the landlord will then provide a lease and say, well, this is the kind of lease you would get, and the parties would then work to negotiate that renewal lease in the same way they renewed the first lease. And only when the lease is settled would the landlord say, here we go, that's what you're getting, and the tenant would then decide whether or not to serve the option notice and to take the lease in that format. So the default is that it's otherwise on the same terms, but in an option it could also be that no, we'll negotiate the form of that renewal lease at the time. One thing to look out for entirely is that if you're a tenant who has a side letter to the lease, so if you're a tenant who had the right to renew by contract, you might also be the kind of tenant who gets side letters, perhaps for nice things like being able to bring your dog to work, or perhaps for more mundane things like being able to carry out, to not insure plate glass, something like that. Those side letters will not renew on your renewal lease. They are not the same terms as this lease. They are outside this lease. So in that scenario, you want the side letters express drafting to capture those as well. Okay, looking at some preconditions that come to do with the 54 Act, sometimes you see that the tenant must not exercise the option until they have given the landlord an advance notice. And if the landlord-tenant does give advance notice, the landlord may serve a warning notice on the tenant. That's the 54 Act warning notice, and the tenant must do the contracting out stat dec. Obviously not applicable in Northern Ireland where you can't contract out the security of tenure. But in the UK, England and Wales, if you want to contract out the renewal lease, you are going to have to do this notice and stat dec procedure that we all know and love to hate, before the tenant is contractually obliged to take the new lease, because you can only contract out if this is done before the tenant is contractually obliged to take the lease. So they're contractually obliged when they serve the option notice, so you need the heads up that the tenant is planning to do that so that the landlord can serve the warning notice, the tenant can do the stat dec. You'll notice that the tenant only has to do the stat dec if the landlord serves the warning notice, because otherwise, of course, the landlord could stymie the operation of the option by simply never serving the warning notice. So if the landlord isn't quick off the mark and serves that warning notice, it might be that the renewal lease would be inside the Act anyway. Okay, but this is not a precondition in the way we looked at conditionality of the option, but it's a precondition to even being able to serve the option notice in the first place. You could, of course, contract out the second lease, the renewal lease, right at the beginning. If you're contracting out both, you could do two sets of contracting out papers right at the beginning of the lease. But that only works if you know the terms of your renewal lease completely before you contract it out, and you probably won't know that in advance. So actually, it's a better idea to do the contracting out just if and when the tenant decides to exercise the option. It may just not be necessary because they don't exercise the option, and it may not work either if you change the terms of the renewal lease, to actually grant it to what you contracted out at the beginning. Right, so let's just have a quick look. Some of the questions are coming through about the interrelation between the 54 Act and the contractual right to renew. And for this, we have to look at Section 28 of the 54 Act. Bit of a techie point to consider, but if you'll see here, it says that if the landlord and tenant agree for the grant of a new lease, the current lease will continue and will no longer be protected by the 54 Act, which does make sense. The 54 Act is there, but actually if you and your landlord have an agreement between you that he'll grant you a new lease, you don't need the protection of the 54 Act anymore. So then the question arises is whether if you've got a contractual option to renew, does that mean by nature of Section 28 that your lease falls out of the protection of the 54 Act because you've got a contractual option to renew? Well, there's no case law exactly on the point, but sort of by extrapolation of existing case law, it seems that really the option to renew would only take the lease out of the 54 Act at the time the option was actually exercised. I mean, under the 54 Act, that agreement has to be in writing. Well, it would be. The agreement for a new lease is contained in the option to renew, which is in writing. But actually, it has to be a settled and firm agreement to take a new lease, to grant a new lease. And actually, the case law would say that that isn't in place until the option has been exercised. So simply having the option to renew doesn't take your lease outside the 54 Act. It would be the exercise of the option that would take your lease outside the 54 Act. And because of landlords not wanting to have tenants having both contractual and statutory rights, it is most common for landlords to insist that the first lease is contracted out of the 54 Act and the tenant has to rely on its option to renew. Right, last slide as we're running out of time. Protection of the option. You need mortgagee's consent, not just to the grant of the lease, but to the grant of the option to renew. So if the landlord has a mortgage over his property, make sure that the mortgagee consented to both the grant of the lease and to the option to renew. The option should be registered. If the landlord's land is registered, then the option will go on the title as a notice. If the landlord's land isn't registered, which is relatively rare, of course, these days, then it goes as a Class C4 central land charge, which is a bit of a blast from the past. If the tenant is in occupation of the area over which it has the option to renew, that occupation will protect the tenant's interest and make it an overriding interest, but best not rely on that, because the tenant might sublet, for instance, or may go out of occupation, and then the overriding interest would be lost. And, you know, it's much better to rely on registration. Key dates diary, yes. Of course, if you've got an option to renew, you've got to remember that you've got the option to renew, and you've got to remember in time to be able to think about it and to actually exercise the option to renew. Typically, lawyers who deal with the grant of the lease and the option won't be there to remind you that the option needs exercising, so we do have to have some kind of corporate memory that the option is coming up. You've got to think, do you want to stay? What is the likely rent to be? You know, what are the likely terms of the lease going to be? It all can't be done at the last minute, so you need to make sure that you remember this option is coming up. The option has to be exercised usually in an option period. Time will be of the essence. If you miss that window of opportunity, and you've probably also contracted out of the 54 Act, you won't be able to stay unless your landlord just plain agrees you can stay. So these are things that might have to be remembered quite a long way in advance. And then we're looking at the form of option notice and the service of option notice. Both can be key to exercising your option validly. The form of option notice will usually be annexed to the lease, so either take care to use exactly what you've been told to use, or perhaps delegate that job to your lawyers. And the same for the service of the option notice. Service is likely to be time critical. If you miss that window of opportunity to serve, you'll miss your opportunity to stay. And there will be service provisions in the lease that deal with the service of notices. So your landlord may have changed, the addresses may have changed, the building may have been sold. So you have to be very careful that you actually make sure that notice is in the correct format and served properly. So again, you may want to absolve that responsibility to your lawyers. Right, I'll stay on to answer any questions. I can see a few questions coming through. As I said, the session is recorded. You can listen to it again. It'll be posted up on this page on our website within a week or so. I have realised that I've run slightly over time, so I'm going to wrap up straight away. If you have any feedback on the session, please just drop me a message through the chat or by email or through the PROPcast page on our website. Likewise, if you want to make a particular topic request for an Eversheds PROPcast, just let me know, or if you want internal training for any of your teams. But in the meantime, I'll just stay on to answer the last questions, but I hope you found the session useful and would like to say thank you very much for joining. Right, just going back through the questions. Can the contractual option to renew be in addition to relying on the 54 Act provisions? Well, I hope I covered that off. I think that's a yes. You can have both, but once you've exercised your option, you have probably lost your 54 Act provisions. But as I mentioned, usually landlords want you to contract out the lease in the first place if you're going to have an option to renew. So definitely you can have both, but you usually won't get both. The next question is, if a landlord wants to enter a lease outside the Act, could the tenant ask for an option to renew instead? I think that's very much the case. I think, though, if a landlord wants you to contract out, they're possibly unlikely to want to give you a contractual option to renew instead. It's usually if they give you an option to renew, they'll want you to contract out, but plenty of leases are contracted out with no rights to stay under statute or under contract. And then a question, the last question here, in terms of the rental renewal, could be stipulated the rent is market rent and then referred. Yes, absolutely. Very often dispute resolution procedures in the normal way you'd see in a market rent clause that actually you either agree the open market rent or else it gets referred. Absolutely. And that is our last question there. Okay, everybody, that's the end of the questions. So I'm going to dial off the call and I'll end the WebEx. Thank you for coming along.